Welcome to the last installment for our review in constitutional law. We are now in public international law. For this segment, it would be helpful if you can also review related matters under constitutional law 1. For example, on the concept of a state, the elements of a state, the requirements for statehood, state recognition as necessary or not in existence or in the creation of the state, sovereign immunity, the role of the president and Congress in treaty making, the powers of the president in treaties, and similar topics which you find could also be intertwined with the topic or the matter of international law. So first up, we go to the definitions. The definition of international law is that it is a set of rules and principles that govern the relationship between states and other international actors. When you refer to states, this is the primary notion of who are subjects of international law. Primarily, it's the states. Because the states, different states, come into agreements or covenants with each other and they become subjected or covered by the mandates and the obligations, and they benefit from the rights under international law. However, under modern uh, international law now also covers international organizations, transnational or multinational corporations or NGOs, as well as individuals. So when you speak of international organizations, these are international or these are organizations with the universal membership of sovereign states. These are established by treaties that provide legal status. Such are subjects of international law and are capable of entering into agreements among themselves with member states. So when you refer to international organizations, examples of them are the UN, the World Health Organization, and the WTO. These organizations, like others similar to them, can enter into stipulations with member states as much as these sovereign states are also able to enter into agreements because statehood allows them external sovereignty. So these states convocate, they conglomerate and form these organizations and they become subjects of international law. So these are the international organizations. Another one are transnational corporations or TNCs. Um, these are entities that are that endeavor in their enterprises or advocacies or their trade across states or across jurisdictions. No, states, international bodies benefit from them. States because they bring in technology, opportunities, labor, aside from fostering foreign relations. No? So they contribute to the accelerated enforcement of international standards and international law, providing the country with a positive image in the international arena. They bring new technologies of goods and services produced in the country in addition to new jobs, infrastructure, and direct investments. So again, who are subjects of international law? These are entities which are covered by the obligations as well as they benefit from the rights of international law directly. These are entities that have the rights and responsibilities under international law. They can be proper parties to transactions involving the application of international law among the members of the international community. Again, they include states. These are the main subjects of international law. Again, international organizations such as the European Union, the UN, IMF, the WTO, and the likes are examples of these international organizations. They have the capacity to contract and they are composed of member nations, sovereign states. Also, in certain instances, as mentioned earlier, TNCs, transnational corporations or multinational corporations or NGOs even, are recognized as subjects of international law in certain contexts. Individuals are not actually originally in a traditional context of international law, not considered as subjects of international law. But the exception is that with respect to human rights law and the international criminal law, individuals or citizens can be considered as subjects of international law because ordinarily private citizens cannot be actually subjects of international law because ordinarily citizens do not are not given personalities in the international arena. They have to redress their grievances or act through their diplomatic officers or through their state in order for them to participate in the international affairs. Objects of international law are persons or things in respect to which rights are held and obligations are assumed by the subject, which are their states. They are not directly governed by the rules of international law. Their rights are received and their responsibilities are imposed indirectly through the instrumentality of an international agency. Okay, so there are three divisions of international law. You have the laws of peace, which governs nations during peacetime. You have the laws of war, which governs participating states during the period of hostility or wartime. And you have the laws of neutrality, which govern states which do not intend to participate in hostilities or which are neutral. The sources of international law are varied, no? Could be treaties or international conventions. They bind parties and they are international law as they are. Customs are practices that have ripened into being part of international law because of the commonality of the practice and the long use of such customs by many in the international sphere. No, the general principles of law. These are principles common to most national systems of law. Pacta sunt servanda, rebus extantibus, estopel, exhaustion of administrative, or sorry, exhaustion of local remedies. Judicial decisions could also form part of international law, specifically those referring to the international courts. No? Teachings of highly qualified publicists, not just any publicist or any self-proclaimed expert, but those who have a fair and impartial representation of law and are acknowledged authorities in their field. They could also be sources of international law. There's this, speaking of customs, there is such a practice or concept such as itong tinatawag na instant custom. What are instant customs? Remember that customs require a long time or consistent practice or usage as tradition requires. However, this concept of new customs have emerged because this due to exceptional circumstances, despite the short period of time, they have ripened into a custom, instant custom. New customary international laws may form in much less time than decades upon decades of consistent practices traditionally required. It comes about as a spontaneous activity of a great number of states supporting a specific line of action. For example, the Bush Doctrine. During the time of Bush, the first President Bush, no, the father, was the 9/11 attack. The 9/11 attack threatened not only America, the US, but also the world in general, because this is a new way of spreading terrorism in democratic worlds, no, democratic states. Gone are the days that they only employ suicide bombings, but now they have the capacity to employ other means that could involve mass injury or death. So during the time of the 9/11 bombing, the Bush administration employed aggressive means of asserting itself, the nation, the US, in protecting its democracy by performing preemptive attacks or more hostile methods of addressing terrorism. No? And this has become an instant custom because this was the same policy which has been adhered to by friends of America, of the US, among others, when they also participated in the drive or the advocacy or the committed um, line of thinking of the Bush administration then, di ba? Because according to George Bush, if you recall during the 9/11 attack, if you are not with us, you are against us. Although a false dilemma, as illogical as it may seem, but that principle of hostility against terrorism was made as an instant custom. No? This concept of treaties as a source of international law. What is a treaty? An international agreement concluded between states in a written form. Well, actually, there were treaties that were made through a non-written, but it's not set out into writing, but they were binding. But this is very uncommon and unusual, no? And governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation, regardless of how you call it, a treaty is a treaty. Now, in our Philippine jurisdiction, it would be best for us to distinguish treaties from executive agreements. Well, treaties, well, they do not come into effect in the municipal jurisdiction unless it is assented to or concurred by 2/3 of Senate. There is no such a requirement for executive agreements. Treaties relate to political issues or change in national policy. They involve international arrangements of a more permanent character. While executive agreements only set down the details of a treaty or may involve matters which are of not so permanent character, no? So treaties are more superior to executive agreements, of course. Treaties also relate to the concept of pacta sunt servanda, the observance of treaty in good faith. Every treaty in force is binding upon the parties to it and must be performed by them in good faith. So this is the Article 26 of the Vienna Convention. No? So signatories to treaties must adhere to them in good faith. The concept of rebus sic stantibus is an exception to the concept of pacta sunt servanda, because the change of the circumstances of the contracting parties may necessitate that parties step back and no longer implement the provisions of treaties. This is an exception to the rule of pacta sunt servanda, legal principle which would justify the non-performance of a treaty obligation if the conditions in relation to which the parties contracted have changed so materially and so unexpectedly as to create a situation in which the exaction of performance would be unreasonable. Jus cogens, some pronounce this as jus cogens. These are non-negotiables, no? These are absolute and uncompromising norms of international law, which no derogation may be permitted. Jus cogens or jus cogens, regardless of how you pronounce it, are not subject of treaty stipulations that would derogate the principles covered by it. Hindi pwedeng i-compromise, no? Such as the provisions on or the norms against torture, slavery, genocide, piracy, acts of aggression or illegal use of force are generally uncompromised. They are not subject to treaty stipulations. For example, an agreement to allow torture, of course, is prohibited. That is jus cogens, no, or jus cogens. To torture, one example is could you torture a terrorist so that he would reveal the whereabouts of the bombs he planted in the city? Well, you consider the principle of jus cogens or jus cogens on that matter. What are the steps in treaty making? The usual steps, according to the UN Charter, begins with negotiation, signatures, ratification, the exchange of instrument of ratification, and then publication and registration are optional steps. In our jurisdiction, treaties require the consent of Congress through the Senate as a further step. No? So what invalidates treaties. You look for this in the notes I have given you. Errors of fact, fraud, corruption, duress, or use cogens. Use cogens. Does the treaty allow for genocide? No, it is invalid. No, the treaty becomes invalid. When a state entered into a treaty for the surrender of its territory, when there was an illegal use of force, it's an invalid treaty because it's duress. No, termination of a treaty. When is a treaty terminated? There are several instances. When the treaty has a term and it already expired, the purpose for the treaty has been accomplished, the performance of the obligations in the treaty are rendered impossible, the subject matter has already been lost, novation, the parties has desisted, the extinction of one of the parties if the treaty is a bipartite, but if the treaty is entered into by several contracting parties, okay, multi-party treaty, then the death or the extinction of one of the parties does not terminate the treaty. Occurrence of a vital change of the circumstances, uh, rebus sic stantibus, outbreak of war, well, it breaks treaties, no? In certain instances, no? Was between participating countries lang, no? And then voidance, or the treaty being considered as void. This concept of clean slate, no, in the succession to treaties, a rule which a successor state generally does not inherit the prior treaty rights or obligations of a predecessor state. When a state dissolves and it is succeeded by another on the same territory, the newly formed state is not required to continue or adhere to any of its existing policies. This could refer to takeover of a state, no, by perhaps invasion or whatever, no. But consider this: in the 1986 People Power Revolution, when the Cory government took over the Philippines, were we considered to have a clean slate? We are no longer bound by treaties? Of course not. Because when the Cory Aquino government took over the Marcos government, there is no dissolution of the Philippine state. The Philippines remained as the Philippines as it is. No new state was formed. In fact, remember the case of Republic versus Sandigan Bayan, involving uh, cronies of Marcos, no? Where because of the interregnum, elements of the state justified the confiscation of properties in a search of premises without a warrant as not subject to the Bill of Rights, because there was no Bill of Rights to speak of, because during that time of the sequestration or the raids done in the cronies' residence, no, there was no constitution as yet, because the 73 constitution has to terminate, and there was yet no freedom constitution, more so a 1987 constitution. But according to the Supreme Court, during the interregnum, we were covered by the Universal Declaration of Human Rights and the International Covenant on Human Rights, no? And as a state, we, during the People Power Revolution, the successful revolution, did not cease to exist as a Philippine state. We did not dissolve. And because of that, we continue to be covered by such covenants. There was no clean slate. Kasi yun ang sinasabi natin, na we could have gotten rid of our agreements for our previous loans and indebtedness. I don't think so. Diba? We still were indebted to the World Bank, the IMF. No? Between a statute and a treaty which governs, we already took this up in Constitutional Law 1 in Cayetano, Pangilinan versus Cayetano. A treaty cannot supersede a statute, generally speaking, no? Because a statute is more rigid in its and participative in its enactment, and a treaty is not as rigid and participative. It's only entered by the executive department, though concurred by the Senate. But a statute undergoes 3 readings in both houses before it is signed into law by the president. So mas rigid and more representative ang statute than a treaty. In the same case of Cayetano and Pangilinan, was the question on the withdrawal from a treaty by the president. Can the president withdraw from a treaty as a matter of policy in keeping with our legal system? Yes. If a treaty is unconstitutional or contrary to the provisions of an existing prior statute. Reading from the case, according to the Supreme Court, however, the president may not unilaterally withdraw from a treaty when the Senate conditionally concurs such that it requires concurrence before it is to be withdrawn, or when the withdrawal itself will be contrary to a statute or a legislative authority to negotiate and enter into a treaty or an existing law which implements the treaty. So those are the exceptions to the general rule that the president can withdraw from a treaty. So let's go to international law as opposed to the municipal law. Are they one and the same? You look at the perspectives, there are two perspectives, the dual and the monist. No? The dualistic perspective regards international law and municipal law as different spheres of law. They are separate. And municipal law can apply international law only when it has been incorporated into the municipal law. While the monist system regard international law and municipal law as one single legal system, part of one single legal system. The latter is subservient to international law. If conflicts exist, international law prevails. Safe to say that the Philippines adheres to the dualistic perspective because international law are not automatically covered by or it made part of local law, except for the general principles of international law, which requires which requires no legislation. The general principles of they are deemed incorporated. Transformation is no longer required, except for treaties. So this doctrine of incorporation, well, I spoke earlier about general principles of international law. Under this doctrine of incorporation, the rules of international law form part of the law of the land, and no further legislative action is needed to make such rules applicable in the domestic sphere. Tanyada versus Angara. An example of this is Article 2, Section 2. The Philippines renounces war as an instrument of national policy and adopts the generally accepted principles of international law as part of the law of the land. Okay? So these are part of the law of the land. As opposed, well, this only refers to general principles of international law. Okay? As opposed to the doctrine of transformation, which requires a treaty or an international agreement to be made part of our legal system to be at least concurred by 2/3 of the Senate first. Because the doctrine of transformation requires an international law to be transformed into domestic law through a constitutional mechanism. And our constitutional mechanism is the requirement of the concurrence of Senate. So in case of conflict between international law and domestic law, what prevails? It depends. If the issue is in the international tribunal, international law prevails. But if the conflict or if the matter is being resolved by the municipal court, the domestic court, then municipal law applies. States, we have this in constitutional law 1, but just to brush up, according to the Montevideo Convention, a state is an entity that has a defined territory, first element, and a permanent population, that's the second element, under the control of its own government, the third element. And the fourth one is sovereignty, that engages in or has the capacity to engage in formal relations with other states. This is what you call external sovereignty. But inherently, sovereignty also is internal when the state is able to control or assert itself internally. Is state recognition required before a state can exist as a state? There are two schools of thought, but the Montevideo Convention adheres to the second one. The first one being the constitutive theory, which requires the recognition of other states before a state can be considered a state. But in the declarative theory, there is no necessity of state recognition for a state to become a state. Okay? That's the declarative theory. But the practicality of it is that if a state does not have recognition of other states, it is difficult for it to come into international relations. So, sovereignty is essential because it is the ticket to the admission to the international arena. because with sovereignty, you're entitled to political independence. Nobody can interfere with your governance. No, you enter into agreement with other states. You are considered as immune. Okay, parem parem non habet imperium, and you can assert your territorial integrity as against others. So we have this concept of earned sovereignty. This allows parties to make evaluations of the effect of independence on the parent state, as well as emerging state success in meeting certain benchmarks before determining its final status. What happens here is that a substate asserts itself to the parent state. So the substate intends to, you know, separate itself from the mother state. But before it does that, civil war normally happens, no, or conflict normally happens. So they can earn their sovereignty or their status as an independent state from the mother state if they are able to establish institutions, if they are able to prove their capacity for independence. Normally, this is done either by themselves or by the intervention of an international body, and subsequently because of an agreement or a referendum, no, which favors the creation of a new state. No? Example is Timor-Leste, is Timor, West Papua, South Sudan, Quebec, and Canada. Some succeeded, some failed. Like East Timor or Timor-Leste succeeded in creating its own statehood. Canada failed because while Quebec failed because while Quebec wanted a separate statehood from Canada, in referendum, several referendums made, um, the Quebecans do not want to separate themselves from Canada. That's why Quebec is still under Canada. So they did not earn their sovereignty. I think this concept of earned sovereignty has hinug na siya eh. Baka eventually pwedeng itanong sa constitutional law. This is a matter that you have to understand talaga. Okay? So, right of legation, on your screen is the photo of the Philippine Embassy, I think in Washington, D.C., no? I think, no? This is the right of legation, no? Um, or the ability of a subject of international law, meaning states, to enter it into their own diplomatic or to send their own diplomatic representatives that you call active legation and receive representatives from other states or passive legation subject to mutual consent of all the parties. So pwede ka magpadala ng ambassadors or consuls, that's active legation, or to receive them, that's passive legation. No? So ano ang functions ng diplomatic mission? Marami. They represent the home country in the host country. They protect the interests of the home country and the citizens of the host country. For example, yung may mga conflicts, may mga gera, international violations of their human rights, they could our nationals could go to our embassies or consular office for assistance. No? Negotiate with the government of the host country for whatever purpose. Monitor and report on the conditions and the developments of the commercial, economic, cultural, and scientific life of the host country. Well, this is not espionage because this is open monitoring. No, this fosters kasi the efficient flow of relations. No, promote friendly relations between the host country and the home country. It's easier for two nations to communicate or negotiate if they have representatives embedded in both their countries. Develop commercial or economic, cultural, and other scientific relations between the host country and the home country. And issuance of passport, travel documents, and the likes, no, including visas. So, what is this matter of immunity, diplomatic or consular immunity? No. This is a diplomatic immunity is enjoyed by an agent who enjoys immunity from criminal jurisdiction of the receiving state. Generally, that's it. No, he shall generally also enjoy immunity from its civil and administrative jurisdiction. So, immunity involves not only criminal jurisdiction but civil and administrative as well. So, ano ang coverage niyan? Personal inviolability. Hindi pwedeng galawin ang isang consul. Immunity from the embassy and legation buildings. Hindi pwedeng pasukin unless with permission. Right of protection. Extraterritoriality. It's an extension. The embassy is an extension of the sending country. No? Exemption from the taxes and personal services. Inviolability of the means of communication because communications of embassies and consular officers are really confidential. And diplomatic bag, these are immune from search. Ano yung diplomatic bag or pouch? These are pouches or packages that cannot be opened by customs or anyone when it is transmitted from the receiving country to the host country and vice versa. Di pwedeng galawin. They are confidential. State responsibility. State is responsible for any harm suffered by a foreign national within its jurisdiction, yung mga turista or diplomats, no? A state can be held accountable for an international wrong if it is proven that either it took part in the act, okay, or was remiss, no? It failed to address the resulting harm appropriately. That's why there are two distinctions here: direct responsibility and indirect responsibility. Direct responsibility is when the state itself is responsible, no, through its agents for the harm caused to a foreigner. While indirect responsibility is kung hindi mabilis ang responde ng state when there is an international a national emergency, like hostilities are open or are being experienced by a state, and the state fails to assist the nationals of another country, or in terms of riots or public uprising, no, the citizens of another country must be protected, no. That's the doctrine of state responsibility. International disputes are unavoidable. That's why it may be settled by amicable methods for most, because that is the mandate of the UN Charter. Techniques used for peaceful settlement of international disputes involve negotiations, inquiry, mediation, conciliation, arbitration, judicial settlement, or resort to regional agencies or arrangements or other peaceful means of their own choice. So some of these methods may include negotiations where two parties directly, in conflict, directly come to a dialogue to talk things out. But international law may require the Commission of Inquiry, which is a fact-finding body, to assist in the negotiations. Mediation is like negotiation, but there is a third party, a neutral party, to come in between the negotiating parties. Conciliation, the organ of conciliation, is normally charged with the task of investigating the facts and submitting to the parties a proposal for a solution. Okay? And you have an arbitral body. It's like a commissioner in our legal parlance here in the Philippines, which are composed of individuals chosen by the parties to help settle these differences amicably among them. No? So, but in certain instances, there are non-amicable methods which may involve retortion, reprisal, severance of diplomatic relations, naval blockade, and embargo. Retortion, this could be the mistreatment by one country of the citizens of another in retaliation to the mistreatments committed. No? Reprisals, these are acts which would otherwise violate the international humanitarian law, but is permitted in order to compel the enemy to desist from its own unlawful conduct. No? Severance of diplomatic relations, naval blockade, embargo, so economic restrictions. No? So you have the UN. The UN is an international organization. No? It's founded after the Second World War in 1945, originally by 51 countries for the purpose of maintaining international peace, security, developing friendly relations, promoting social progress, better living standards, and human rights. So the UN is intended to maintain peace and order, harmony among nations. Its membership is open to all peace-loving states, which accept the obligations contained in the charter. So they should be willing to accept the provisions of the UN Charter, and they are, by the determination of the organization, by the UN, are able and willing to carry out these obligations. They are admitted by the General Assembly upon the recommendation of the Security Council. Note here that China is a permanent member of the Security Council. It's among the permanent members of the Security Council. That's why it's difficult for Taiwan to become a member of the UN, because China is there. And China is opposed to the statehood of Taiwan. The organs of the UN include the GA, the General Assembly, the Security Council, the Economic and Social Council, Trusteeship Council, International Courts of Justice, Secretariat, and other such bodies that may be created, no, in furtherance of the intentions of the present UN Charter. No? For the descriptions, you kindly look at the notes I have sent to you. Let's go to the special topics in international law. Extradition. What is extradition? The surrender of one nation to another of an individual accused or convicted of an offense outside of its territory and within the territorial jurisdiction of the other, which being competent to try and punish him demands the surrender. So is this a requesting party? The individual may have committed an offense in the territory of the requesting party, and that requesting party requests another country which has jurisdiction over the individual, no, because he is within the territory of the requested party. So it is not part of international customary law. Therefore, a treaty is required. Okay, only a treaty could allow extradition. The extradition treaty, you call it an extradition treaty, creates the reciprocal obligations to surrender persons from the requested state's jurisdiction charged or convicted of certain crimes committed within the requesting party's territory, and is of the same level as the law passed by the Congress of the respective states or respective parties. So similarity, no? This is what you call the principle of dual criminality. It simply means that the requesting state must comes under no obligation to surrender the person if its laws do not regard the conduct covered by the request for extradition as criminal. So if there is no crime if the act in the requested state is not considered as crime, nullum crimen nulla pena sine lege, it is not considered as a crime there, then it cannot extradite that same person who is requested by the requesting party to be extradited. That's what you call the double criminality rule. Okay? The treaties outline the circumstances under which the extradition may be refused. Typically, individuals cannot be extradited for military or political offenses, although exceptions are made for terrorism and other violent crimes. Additionally, some countries will not extradite individuals to jurisdictions which impose capital punishment or life sentences unless the requesting state guarantees that no such penalty will be imposed upon them. Outside of the treaty, there is no rule in international law compelling the state to extradite anyone because this is not part of the general customs of law. No? Treaties are essential. In the Philippines, we have the general law on extradition, PD 1069, which defines extradition and also the procedure for extradition. So again, under 1069, extradition may only be allowed if there is a treaty. Okay? So look at the law for its procedure. This principle of non-refoulement, it prohibits states from transferring or removing individuals from their jurisdiction or effective control when there are substantial grounds for believing that the person would be at risk of irreparable harm upon return, including persecution, torture, ill treatment, or other serious rights or violations. Serious human rights violations. For example, those seeking asylum or those who are refugees from a tumultuous from a country that's experiencing discrimination or human rights violation. No? So the state that receives these refugees, for example, has no obligation to return the refugees to their mother country if so asked, if there is a threat to harm against them. Okay. Example, under the Covenant on Torture and Other Cruel and Inhuman or Degrading Treatment or Punishment, as well as the same convention against enforced disappearances. This is discussed, by the way, these two covenants or conventions are discussed in Consti 1 or Consti 2. Kindly refer to the video or the notes. The state is not compelled to expel or return the refouler, no, or extradite a person to another state where there is the danger of torture or cruel or degrading or inhuman punishment, or when there is the danger of enforced disappearance. The scope of non-refoulement applies to any form of removal or transfer of persons regardless of their status where there are substantial grounds for believing that the returnee would be at risk, no, of harm. It is characterized as absolute, meaning it's without any exception. Okay, when there is harm, threat of harm, non-refoulement could be implemented. No? The prohibition applies to all persons irrespective of their citizenship, nationality, statelessness, or migration status. The use of force. This is covered by the UN Charter, Articles 2.3 and 2, Paragraph 4. No? All members shall settle their international disputes by peaceful means in such a manner that international peace and security and justice are not endangered. But mainly, this is under 2.4. All members shall refrain from, in their international relations, from the threat or use of force against the territorial integrity or political independence of any state, or any other manner inconsistent with the purposes of the United Nations. I wonder how this applies to China, who threatens us with the use of force in the West Philippine Sea. Diba? And the force that they are using is not only actual but also, implied. No? Does this cover economic blockades or restrictions and cyber attacks? Well, um, cyber attacks, according to Waxman, is a use of force. The traditional concepts of force in international law may apply to cyber operations, in cyber attacks, considering that their potential to cause harm, disrupt essential services, and violate state sovereignty. So indeed, cyber attacks may come under the category of the use of force. How about economic and other sanctions? This is in a way a use of force, but this use of force in the manner of economic and other sanctions have been employed as a lower risk and lower cost of action than diplomacy and war. No, this is in fact a temporary sanction prior to war. No, while the state is contemplating of war. There are exceptions to the use of force, self-defense. This is passive, no? Then military action or authorized by the UN or competent regional organization, NATO and the likes, no? Um, this is it could be aggressive, no? But also for humanitarian missions, the UN peacekeeping force may be sent to maintain peace, and in maintaining peace, they may be allowed to use force. This concept of um, sovereign immunity. This is also an important special topic, no? We have taken this up in Constitutional Law 1, Jusmag versus NLRC, under the principle of par and parem non habet imperium. An equal has no power over an equal. Since all states are equal under the Montevideo Convention, a state cannot compel another to face litigation in its home court, in the court of its home country. A state cannot sue another state in its own home country because we are all co-equals. No? The Calvo Clause. The Calvo Clause is a clause which is frowned upon under international law, but this is a clause which is included in contracts where foreign individual consents in advance to forego in seeking diplomatic protection from their home country in case of breach in their contract or similar instances when they could have obtained the assistance of their home country following international law. War. What is war? A phenomenon of organized collective violence that affects either the relations between two or more societies or the power relations within the society. This is governed by the international humanitarian law. These are the rights of the persons during wartime to be treated humanely, the right not to be tortured, the right to communicate with their families, food, clothing, religion, articles, religious articles, medicine, bare minimum of information, personal belongings, proper burial. These are all under the Geneva Convention. The Geneva Convention is a series of modifications to the original convention in 1949. Look at the Geneva Convention for a more detailed discussion on the rights of the prisoners during wartime. Okay, even the repatriation of the sick and the wounded. No, kasama niyan is during wartime, there should be the adherence to the basic principles of the law on armed conflicts. And these are the basic principles of the law. No? Distinction, the principle of distinction. You must always clearly distinguish between combatants and civilians, unless the civilians take up arms and become combatants. You do not harm civilians. Second, proportionality. Incidental damage must be not excessive in relation to the direct concrete military advantage you anticipate from your operation. So you do not employ such violence when it is not called for. Proportionately respond to the attacks against you. Okay. Military necessity, the only legitimate object which states should endeavor to accomplish during war is to weaken the military forces of the enemy. So it allows for whatever reasonable force is necessary, is lawful, and can be operationally justified in combat to make your opponent submit. And that's it. Just make them submit. Do not employ strategies which are excessive. No limitation. The weapons and tactics that are of a nature of to cause the unnecessary suffering or superfluous injury. No, like chemical warfare. No, which could injure infants, minors, non-combatants, and it's indiscriminate, like landmines. No, so limitations na they do not overly cause suffering. No, good faith even during wartime. Commit to good faith between opponents. Okay, military should show good faith in the interpretation of law of armed conflict. Okay, especially in negotiations for peace during wartime. No, humane treatment and non-discrimination during wartime. Do not discriminate people. No, sama dyan. By the way, yung excessive employment of force, yung mga rape, yung mga ganyan, di naman kailangan sa gera yan. No. Anyway, humane treatment and non-discrimination also covers that all persons must be treated humanely and without discrimination based on sex, nationality, race, or religion, or political belief. Those who are already injured, no, need not be attacked. No, when they surrender, or air crew when they parachute from a downed aircraft, don't attack them. The wounded, the sick, and the shipwrecked prisoners of war must be treated humanely. Okay, so practically, um, that is the end to the constitutional law review. My advice for those who are intending to take the bar for you is just foremost remember the basics, meaning the provisions of the law, the constitution, the provisions of the law itself. For election law, you have the omnibus election code and the basic laws, the local government code, basic the UN Charter, the Geneva Convention. Go to the provisions. Never forget the basics because the basics are consistent. No? Jurisprudence may change, but the codal provisions of the law are basic. When you answer your exams, keep it simple. Do not respond to matters which are not asked during the bar exam. Only stick to the question. Stick to the general concepts if you are unsure of the exceptions. And you have to study. Do not stop studying until you reach your goal. Because in fact, when you become lawyers, you don't stop studying. Still study as well. You study not only for the bar, but also for the practice of law. You also try to give it your best shot. Your best shot is your best shot. If in case you are a religious person, don't forget to pray. So thank you for bearing with me and for viewing my videos. Have a great day.